Welcome to Legal Lines. My name is Tom O'Shea, the host of this program, brought to you by the York County Bar Foundation. Our topic tonight is automobile insurance, and my guest is attorney Craig Milsten. Welcome, Craig.
Thank you.
Craig is an attorney with Catherman, Briggs & Greenberg, or KBG law firm, and they do many personal injury cases, including motor vehicle cases.
That's right.
Correct. And the topic of insurance, we were just talking before the show, and I still use the term no-fault insurance. And you're saying that's not in vogue anymore.
It's still applicable. I just don't tend to hear it as much these days. Auto insurance, practicing in this area of the law and handling motor vehicle accidents, we have to be very familiar, of course, with all of the tenets of auto insurance law because it is so intertwined with the cases that we're doing. And one of the things that I've learned is that pretty much nobody actually understands what's in their auto insurance. I think that when most people go to purchase auto insurance, their two top priorities are number one, to spend as little as they possibly can, and number two, to get out of there as fast as they possibly can. And it's really only after an actual accident occurs that people then go back in and go through the process of finding out what it was that they actually purchased.
Okay. Well, the first thing is that under Pennsylvania law, if you're going to drive a vehicle, you have to have motor vehicle insurance.
That's right.
It's a mandate. However, there are only minimums that are mandated. Am I correct?
Well, the first thing that's mandated is that you have auto insurance.
Right.
And then beyond that, that's correct. There are certain coverages which are mandated and have minimums. And those coverages are your liability coverage, which is the coverage that you have if you are the one who causes the accident and causes injury to another person. Your liability coverage is the amount of money that's there to compensate that other person. So currently in Pennsylvania, the liability mandatory minimum amount you can have is $15,000. Now, it has been at that level for a very long time, and there are efforts underway in the legislature now to raise that to bring it more into line with modern economics.
Okay, so basically to drive a vehicle in Pennsylvania, you have to have motor vehicle insurance, but you're saying that the minimum is only $15,000?
That's correct.
Now, what does that cover?
Again, that's the amount that you have to compensate another person for their economic and non-economic losses if they get hurt. So by that I mean if you hurt another person and they're not able to go to their job, they're not able to earn wages, they now have lost wages, those are part of their economic losses. So that $15,000, if you have the minimum amount, has to cover that. In addition to that, the other person that you have hurt has suffered. They have suffered an injury, they've suffered pain, they've sufferred, they can't do the things that they normally like to do. Their life has been impacted. And so they are entitled to non-economic damages, which is otherwise known as pain and suffering. So that $15,000, or again, you don't have to have the minimum amount. You could have $25,000 or $50,000 or $100,000 and up. But that amount is there to compensate the other person for their losses.
All right. So if I'm purchasing motor vehicle insurance and I want to pay the least amount possible, I'm going to buy the minimum coverage.
That's correct.
But that might not be the best thing to do.
Well, I think we're all probably familiar with the commercials on TV, and when you hear things like, we cover you for less or minimum coverage for minimum payments, that sort of thing, that's really what they're talking about. It's what you have to have by law, but it's the least that you can possibly have, and therefore it will cost you the less. Now, the downside to that, of course, is if you injure somebody and that person's losses are greater than the amount of insurance that you have available, your liability policy, then your insurance company will pay what they have. They'll pay the policy limit, but then anything beyond that, you're potentially responsible for yourself.
So if right now, let's face it, $15,000 is not a very high amount for somebody who's in a very serious vehicle accident.
Well, and you're right. And that's one of the reasons why we have a law which mandates auto insurance in the first place. It's because we recognize that automobiles, as wonderful and useful as they are also big and dangerous, and that people make mistakes And when people make mistakes doing with something big and dangerous, you can hurt somebody and you can hurt them very seriously. And so that's why we want to have that amount of money there. And so you're right. If you make the wrong kind of mistake and have a bad outcome, it can certainly be expensive.
So like with anything else, you get what you pay for. And if I buy just the minimum and it's $15,000 and I cause an accident where somebody is badly injured and it exceeds the $15,000, the rest of the liability falls on me personally if I cause the accident.
Correct.
And if it was $100,000, I'm responsible for the $85,000 that the insurance didn't cover.
That's true.
And if I own a house, it could be subject to a lien or be used to help pay the liability that I have.
That's all possible.
Okay, or money in the bank or whatever other assets I might have might be lost if I don't have enough motor vehicle insurance coverage.
You're absolutely right.
So when you shop for insurance coverage, don't just think about the price of the insurance. Think about what you need to cover.
Correct.
Okay. Now, with respect to that, I understand there's something that's called full tort coverage or limited tort coverage.
Yes.
What does that mean?
As I said, people tend not to know what's in their insurance. And the first thing they're usually not sure about is which one of those they have. And then the second thing is, even if they do know which one they have, they typically don't really have an understanding of what that means. So here's what it means. And let me start with this. It is full tort, T-O-R-T, and limited tort, not torque, which is the other misperception that people sometimes have. So full tort and limited tort is a Pennsylvania construction, meaning that this is just the way we do it here in Pennsylvania. Other states don't necessarily do it this way. This is our system and our way of dealing with this. And when the legislature came up with this back in 1991, the purpose of doing that was to stratify auto insurance, make it so that there was a lower cost option if people wanted to have it. And so what it has to do with are those damages that I talked about. So if you are injured in an accident that was not your fault, there are two kinds of damages that you're entitled to, I mentioned before. The first one being economic damages. Economic damages meaning actual money that you have lost as a result of being in an accident. For a lot of people, lost wages, out-of-pocket medical expenses. There's other categories, but those are the main ones. The second kind of damages are called non-economic damages, which I also explained before, essentially pain and suffering. And so when we come back to this full tort and limited tort question, what that is really is a deal that you are making with your insurance company. And the deal is limited tort costs less. You select limited tort, your premiums will be lower. But naturally, you are giving something up in order to have lower premiums. And what you are giving up has to do with the kinds of damages that you are entitled to when you get into an accident. If you are limited tort and you get into an accident that's not your fault and you're hurt, you are still entitled to your economic losses, your lost wages, out-of-pocket expenses. You are not entitled to any of your non-economic losses. So if you are limited tort, and to put it as succinctly as I can, if you are limited tort and you get into an accident, you will not get compensated at all for your pain and suffering. Now, having said that, and of course, if you are full tort, then you're entitled to both. Mm-hmm. Now, having said that, the law does enumerate certain exceptions such that even if you elected limited tort, if one of these exceptions applies, then you're not bound by your limited tort, and you can still get both kinds of damages. So of the exceptions that exist, the primary ones are if the person who caused the accident was driving a vehicle that's not registered in Pennsylvania, so in other words, this is an out-of-state driver, but it's got to be the vehicle, not the driver, it's from somewhere else, then you're not bound by your limited tort. And the reason for that is, like I said before, this is just a Pennsylvania thing. These are the rules that we play by. So if somebody from Maryland or New Jersey or another state hits you, they don't get the benefit of that. The other exception is if the other driver who caused the accident is convicted or pleads guilty to driving under the influence of alcohol. We're not going to allow them the benefit of your limited tort election under those circumstances. If you are occupying a commercial vehicle at the time that the accident happens, in other words, the vehicle not owned by just a regular person, but owned by a company of some kind, then you are not bound by your limited tort. And then the last one, if none of those apply, there's one more, which is called the serious bodily injury exception. It's somewhat self-explanatory. If the injury you suffer is legally determined to be a serious bodily injury, then you're not bound by your limited tort.
And in that case, it would be treated as full tort even if you purchased a limited tort policy.
Correct.
Now, full tort would cover everything, including pain and suffering.
That's right.
Can you try to explain what pain and suffering is and how it's measured?
Sure. And again, the broader term is probably non-economic damages, of which pain and suffering is one. Anxiety, mental distress, inconvenience, loss of life's enjoyment, the inability to do the things you like to do. Those are all your non-economic damages. So, pain and suffering, the interesting thing about pain and suffering in Pennsylvania is, and people always ask, so what's my pain and suffering worth? And the first thing to note is, this is a weird question to even ask. How do we assign a dollar amount to your pain and suffering? And the answer is, it is whatever the jury says it is. And while that's a very unsatisfying answer, I'm saying that because when you have a case, if that case is going to go to trial, we do not get to ask the jury for a specific sum of money. I know that sounds a little different than what you hear sometimes on TV, but in Pennsylvania, it's an open-ended question. You don't get to say, please award us X number of dollars. The other side doesn't say it. The judge doesn't say it. The jury's left completely to their own devices to come up with that. And so the value of your pain and suffering ultimately is whatever a jury says it's worth, and they can base that on whatever it is they want to base that on.
Now, you're saying it's up to a jury, but most cases never go to the jury.
Correct.
Most cases settle.
Correct.
So people who do a lot of insurance defense work or plaintiff's work on behalf of injured parties in accidents pretty much know what settlement would be. A proper settlement amount would be.
Well, the way to approach it is to start with this premise. Every single case pretty much has to end in one of two ways. There's only two things that can possibly happen. Option A is there's a settlement. All right, both sides agree on a certain sum of money, they pay it, a release is signed which says you're not responsible anymore, and the case is over. If that doesn't happen, the only other path that the case can travel is there's a lawsuit filed against the at-fault driver. And then, again, if the case still doesn't settle, it travels through litigation, which is basically preparation for trial. And then it goes to trial. And then a jury decides what the outcome should be. And the reality is that most cases will settle without going into litigation. Even of the cases that do go into litigation, the vast majority of them will settle before getting to trial. And the reason is because it takes a very long time for a case to get to trial. There's a lot of additional expense involved in that litigation process. And then, of course, there's a lot more risk at the end of the day. There's good outcomes and bad outcomes for both sides at trial. And so the reason why most cases tend to settle is because both sides are trying to manage those three factors, and not take those risks.
Okay, so somebody who's handled many of these cases would generally have a good idea on what a proper settlement amount would be.
And by that, what we're really saying is I am predicting what would happen if your case had to go to trial.
By the way, we only have a few seconds left in the first segment of this show. Medical expenses, are they covered regardless of what type of insurance you have?
Yes, and that's the no-fault law that you spoke of.
So that would be the actual medical bills from any injury that may occur. That's covered automatically as part of the insurance.
Well, it's covered out of your medical benefit on your insurance.
And we'll talk about that in the second half of this program. This is Legal Life. Welcome back to Legal Lines. Our topic on today's program is motor vehicle insurance. My guest is attorney Craig Milsten, and right before the break we were talking about the medical insurance or the medical benefits from motor vehicle insurance. And what exactly are those benefits?
Medical benefits are another coverage that you have to elect how much coverage you want. You can't elect not to have it. You have to have it, but you can elect how much you want. So the mandatory minimum is $5,000. So if you have auto insurance, you have medical benefits associated with that, and it's no less than $5,000. It can be more, of course. You could have $10,000, $25,000, $50,000, $100,000, but at a minimum, $5,000. So one of the interesting things about Pennsylvania auto insurance law is if you are injured in an accident that was not your fault, somebody else caused it, it is nonetheless your auto insurance medical benefits that pays your bills first. And I know that sounds odd to people. Well, why should my insurance pay if I didn't cause the accident? And the answer basically is because that's the way they all agreed they were going to do it.
Well, that's part of the reason it's called no fault, if I'm correct.
That's exactly right. So the term no fault insurance or no fault as it applies to auto insurance in Pennsylvania, that's what they're talking about. It doesn't really apply to the other areas, but it applies to that, which means that it doesn't matter if the accident was your fault or the other guy's fault or whoever's fault. If you are injured in an auto accident, it's your auto insurance that pays first. And it's important to understand, too, you never have to pay that back. The other side doesn't have to pay that back. Your auto insurance pays, and that's the end of the story.
All right. So what's the state minimum that you need?
The bare minimum that you can have is $5,000, which, in today's health costs, of course, doesn't sound like a lot of money. It does go a little bit further than you think it does in this context because, again, our legislature regularly enacts laws with the idea of trying to hold down the costs of auto insurance. And so they also did that not that long ago where they passed a law which is commonly known as Act 6. And what Act 6 does is it actually specifies how much a medical provider can be compensated for treatment that it provides related to an auto accident. And it's a pretty low compensation rate in the grand scheme of things. So that $5,000 actually goes a little further than you think because they hold down the costs.
I see. So if somebody needs a procedure as a result of a vehicle accident, the medical provider cannot charge more than the amount that the state says it can if it's covered by this insurance.
Right. Well, and just like the way health insurance works, the provider has whatever charge the provider has, but when it gets submitted to the insurer will only reimburse the allowed amount, and the provider is not allowed to ask you for the difference.
I see. So it still would benefit someone purchasing this insurance to have higher than $5,000, I would assume.
Yes. So, when you're injured in an accident and you start getting treatment, you use this medical benefit to pay for it. It's a terrific benefit because there's no copay, there's no deductible, there's zero out-of-pocket cost to you while you're using it. In addition, unlike health insurance where the rules can sometimes be complicated about what doctor you can see or where you can go, those rules don't apply here. You can go straight to a specialist if that's where you want to go to. And people who are injured in auto accidents should do that, should go to an orthopedist if they have orthopedic injuries. However, if you use up that entire medical benefit, let's say you have the minimum $5,000 and you're treating and you've now used up that whole amount and you still need more treatment, the next source of payment would be health insurance if you have it.
Your own personal health insurance.
Correct. And of course, if you don't have health insurance, then it's just straight out of your own pocket. Now, even if you do have health insurance, unlike while your auto insurance was paying, health insurance, you almost certainly are going to have copays, deductibles, out-of-pocket costs on your own. Now, those are losses which you should be able to get back from the at-fault driver eventually, but it's not a one-to-one thing. You've got to pay it first. The other issue that arises is even when your health insurance is paying, certain health insurance plans, depending on how they're constituted, will then have a right of reimbursement. So, in other words, normally when you use health insurance, you need it for something, health insurance pays, nobody ever pays them back. It's what you have it for. But if the reason you're using that health insurance is because of somebody else's negligence, and you brought a claim against that other person, and you received money from that other person, then certain health insurance plans that have this right have a right to get reimbursed. And that's what's known as a lien. That can cause a major problem in a case sometimes, because relating back to what we talked about before, let's say the other driver has a minimum policy. Let's say there's only $15,000 in total liability insurance here, and you're seriously injured, and you used up your entire medical benefit, and then you kicked over to your health insurance, but health insurance now has paid thousands and thousands of dollars, and they have a right to get repaid. But there's only $15,000 to go around. You know, where there are situations that exist, we sort of refer to them as coverage tragedies, where there are horrible, debilitating, permanent injuries with enormous costs and not enough insurance to even cover the lien. So, getting back to your original question, you can have more medical benefit. It's an excellent thing to have more medical benefit, because then, number one, of course, no out-of-pocket costs on your own. Everything just gets paid for. And number two, you don't run that risk of having a big lien in your case, which is going to potentially use up all of the available funds.
So here again, when someone is purchasing motor vehicle insurance, they need to think about the fact that these things do happen. And if they just buy the minimum coverage, they might find themselves in a situation where they get nothing other than their medical bills paid, because there might be a lien by the insurance company to be reimbursed for all the expenses that the person incurred. And even then, if that $15,000 doesn't meet that amount, they're personally liable for the rest. Well, I guess except for what their own personal insurance would cover.
Right.
That makes sense then. I had to think that through. But nevertheless, I mean, these are the things you have to look at when you're purchasing a policy.
That's right.
All right. Now, one other thing you have to think about when you purchase a policy is whether you have something that's known as underinsured or uninsured coverage. Now, can you explain what that means?
That's right. So these two things usually go together, and it's uninsured motorist coverage and underinsured motorist coverage. You can sort of deduce what they're about, but it has to do with if you are hit by another driver, the accident is the other driver's fault, and you are hurt. It has to do with the amount of insurance that the other driver has. So even though that we have laws in Pennsylvania that everybody has to have auto insurance, it may come as a surprise to you that not everybody follows that. And so there are people driving around that do not have any auto insurance. And if you are the victim of an accident where the other driver has no insurance whatsoever, and you are injured, then there's absolutely nothing there to help you. There's nothing there to pay your economic losses. There's nothing there to pay your non-economic losses, unless you have elected to take uninsured motorist coverage on your policy. So that's a benefit that you pay for to protect yourself. So in other words, unlike your liability policy, which is there to help protect other people primarily, uninsured and its co-part underinsured are there to protect you.
Okay, so the uninsured is simple enough. The other driver did not have insurance. The underinsured would be the driver who's driving around with the bare minimum or something close to the bare minimum.
Exactly. So let's say, just to put an example on it, let's say that the other driver has, like we said, one of those state minimum $15,000 policies. They hit you, and at the end of the day, your case is worth $50,000. What would happen there is you could still get the $15,000 that the other driver has in liability coverage to compensate you, and then you would turn back to your own policy and your underinsured motorist coverage, if you have it, and then that is there to fill in above the other driver's coverage up to the value of your case. So if you had enough coverage, you would get $15,001 up to the full $50,000 value of your case.
Right. So under Pennsylvania law, everyone's required to have motor vehicle insurance. Are you required to have coverage for the underinsured or the uninsured?
You are not required to have it. You can waive it. Now, you have to sign a specific form to say that you are waiving it. And I'm going to tell you right now, do not do that. Okay. This is one of the biggest mistakes that you can make while you're purchasing auto insurance. As I said, and underinsured coverage is exceedingly important for you. And I'll lay out the super simple example of it. Let's say that you are the victim of what turns out to be a debilitating, permanent, tragic accident, and you can't work for the rest of your life. Are you going to rely on just whatever amount of money that other person was purchasing when they went to buy their auto insurance? Because that's it. That's all that will be there to compensate you. So you want to have as much un- and underinsured coverage as you think you need to protect yourself in that instance. Now here's the catch. You can't just walk into your insurance agent and say, I would like to have a bare minimum liability policy to protect everybody else, but give me $1 million worth of underinsured and uninsured coverage to protect me. They don't let you do that. You can only have as much un- and underinsured coverage as you have liability coverage. So if you want $1 million for yourself, you've got to have $1 million for everybody else.
I see. So you have to protect everybody else to the same extent that you're protecting yourself.
On that issue, correct.
Okay. All right. So cost-wise, again, people might think that they're saving some money by not having this. But
Don't do
really,
that.
the insurance is going to do very little for them if they have a need for it.
I'll tell you the most common scenario where that comes up. So not only do they give you the option of waiving these two coverages, which do not do, but they also will give you the option of what's called signing down that coverage. So they're obligated to offer you as much un- and underinsured coverage as you have in liability coverage. So let's put numbers on it. Let's say you have $100,000 in liability coverage. They have to offer you $100,000 in those two coverages. But then they say, you know, if you want to save a few bucks, here's what you should do. Instead of taking the full $100,000, let's drop that down to $50,000, and then that'll cut down on your premiums. People like the sound of that, and so they do it. Again, this is the most important coverage possibly on your entire auto insurance, declarations, and you need to not skimp there. Okay, 2 rules: pick full tort, and do not skimp on your un- and underinsured coverage.
We have about a minute left. If I'm going out to purchase insurance and I want to have good coverage, what should I be looking for? I mean, I go to an insurance agent. I might be like anybody else and just want to look for the cheapest cost.
Yeah.
What should I be looking for in order if I'm looking at a policy?
Well, the reality, of course, is that everybody's, economics are their own, and everybody only has X amount of dollars to spend on things. But the cardinal rules, which I just said, are full tort is a much better option than limited tort. You may save a few dollars up front on limited tort, but all it takes is one accident. You will wipe out all of those savings and possibly a lot more. Full tort is what you want. The second area is buy as much un- and underinsured coverage as they will let you buy. Do not sign that down. Do not waive that. That is what you want. And then the third one, if you can, for un- and uninsured, I know we haven't done a whole lot on that, but you can actually buy what's called a stacking option, where you get that benefit times the number of vehicles on the policy. It's a very inexpensive feature that can multiply the amount that you have available to you. I strongly recommend that too.
All right, we only have a few seconds left, but stacking, if I have 3 vehicles.
If you have 3 vehicles and you have $100,000 in underinsured coverage, but you have the stacking option, you now have $300,000 worth of un- and underinsured.
Okay, well, we're out of time now. My guest today was Craig Milsten from KBG Law Firm, and this was Legal Lines. Thank you.